Good morning. Hey, everybody. How are you? My name is Debbie. Welcome to my channel. I hope everybody had a fantastic weekend. Good morning. Good morning. Hey, everybody. Hey, Judy. Hey, Jennifer. Hey, Teresia. It's so good to see everybody this morning. Let's see what Judy. Hey, Carla. Let's see what Judy has for us today. A desk in Spector's home was adorned with a poster of a pew pew with the caption, "Never mind the dog, beware of the owner." Oh boy. Wow. Hey, Jelly Bean. Good morning, everybody. My stepdaughter just sent me this cute little Facebook reel, and apparently it's a nurse at medical school just learned something, taught me as well. Um, Drinking Crystal Light prevents kidney stones because it has citrate in it, and citrate binds with the calcium in your urine, and that is what forms one kind of kidney stone is calcium. So it binds with the calcium that forms kidney stones. So then you don't get kidney stones. So I have almost completely quit drinking Crystal Light. I still have some up there in my cabinet. Um, but I just grab a bottle of water instead of putting the, because when I first started drinking water, I did it out of necessity pretty much, because between dieting and being a diabetic, after you have weight loss surgery, they tell you to lay off the carbonated drinks. So even though I had switched to diet soda because I was trying to lose weight, they don't want you to have the carbonation, because like after you have stomach surgery, that the bubbles in there like still puff up your stomach. So I had switched to drinking a lot of Crystal Light, and then I just switched over to water because just drinking water was yucky after years and years of soda and tea. And so I always put Crystal Light in it. And then I eased off Crystal Light and was just drinking water. I just grab a bottle of water. And um now I think I'm going to go back to the Crystal Light. But as Wiggles constantly reminds us, I'm a freak, and when I did have kidney stones, I did feel it. But I did have to go through all the horrible treatment for them, even though I didn't feel the stones. I still suffered through the treatment of having them. It was not fun. So, so yes, I'm a freak that didn't feel her kidney stones, but I felt the treatment. That was not fun either. So, I think I'm gonna go back to drinking Crystal Light. So, anyway, so we had some tech issues at the end of the first part of closing arguments in the Phil Spector trial. We are still on the prosecution's closing. It is 4 parts. That's like 4 hours long. We've the longest closing in history, but it was a 5-month trial. So I have got it queued up to about where we left off. It's only like 3 minutes left of the first hour of closing, and then we're gonna do the second hour of closing, and then we're gonna go to Wackadoodle's trial. So let's go ahead and get started so we can get all of part 2, and then tomorrow we'll do part 3, and the next day we'll do part 4, and hopefully we'll have closings done in about 2 weeks. Well, maybe. I don't know. Let's see. This trial's supposed to last the Wackadoodle trial is supposed to last 2 weeks. So we have about another week of that. Week and a half. And Donald Donna Adelson's trial starts on the 19th. We might not have a break. I was gonna say we should have a break in between where we can get finished with this one, but I don't know if we're gonna have a break in between. I don't know. Let's just get started. I have ADHD. I don't know how to do time management. I hope we don't have tech issues again today, but wishful thinking. Because we always have tech issues with StreamYard.
Two things we know for sure about Tawny Tyndall. She didn't testify in this case, but we found out two things for sure. She doesn't record any of her conversation together, wouldn't you think? One of the things, and Mr. Rosen is an outstanding cross-examiner. And one thing that I have to take credit for Mr. Rosen being accomplished at cross-examination. He had transcripts to cross-examine one of our witnesses with. Because our investigators record their conversations. Why? Because we got nothing to hide. It is. And if you sit down with someone and you don't have a tape recorder, I understand that. I dig that. It's fine. You're out, you meet a witness, you don't have, okay, fine. But if you're going to a location in order to interview a witness, tape record them. What are you hiding from? We're after the truth, right? Tawny Tyndall didn't record a single conversation, so we'll never know, and more importantly, you will never know what her conversations with Pumpkin Pie and Jennifer Hayes and those folks really consisted of. You'll never know what her conversation with Daniel Stark really consisted of. And the other
Seriously, StreamYard? We're 1 minute in. 1 minute.
people said, oh yeah, I was contacted by the lady. She had long blonde hair and her lipstick was a little too red. Her name was something funny to him, and I'm not being pejorative. I mean something odd, I should say. Some extraordinary. Tawny Tyndall. He was shown a photograph. Has face to the public that is the investigative agency. She gets information from Bruce Liverpool she doesn't like because he said, no, you know what, look, based on the information that you're giving me, I don't think she was under the influence. I can't say that. Okay, thank you very much. And by the way, who are you with? Who are you with? Oh, I'm with a civil firm. Don't worry about, I'm with a civil firm. My name's Tawny. I'll talk to you later. This is a civil case. Literally lied to his face about who she was. Why? Why would she lie? Why would she lie about her identity? The next phone call that firefighter might make is to the DA's office. Hey, I was just contacted by the defense, and they asked me X, Y, and Z. Lie about your identity? Jackson and Dixon? They'll never know. And we can have Daniel Stark take the stand and tell the jurors basically anything we want them to. And they'll never know. Oops. Think about the photographs. Sorry, Judge.
I was just about to ask. The timing to break?
Yes, thank you.
Okay. No problem. It's time to take recess. Keep in mind the admonition will be in recess for about 15 minutes. Thank you. When the jury is gone, I need to address some people in the audience. I suggest hold on for a minute. Thank you. Go ahead and have it in the jury room, ladies and gentlemen. All right, the jurors and the alternate. parties, jurors, and alternates are present and certified for. You may resume.
Thank you.
That was a perfect, beautiful transition on my end. StreamYard effed it up. I was so proud of myself.
Everybody feel better? To make was think about in the back of your mind, again, this is just a quick list of things to think about when you're assigning credibility, the character and the quality of the evidence that you've been presented. Think about the photographs of Lana Clarkson that the defense chose to use over and over and over. Let me bring this back up to Daniel Stark. You remember Daniel Stark was on the witness stand, identification of who it was that he claimed was perfectly acceptable. Nothing wrong to make identifications, make sure we're talking about the same folks, right? So the defense chooses a photograph. I was aghast. It was remarkable to me. The defense had, first of all, I should say this, the defense had available to them, just as you had available to you, probably dozens, if not dozens, at least a dozen photographs of Lana Clarkson headshots. Usually in a trial, and we have to make an identification to do with EM photo or something, because none of us are making headshots. Lana Clarkson had tons of photos. If all you want to do is identify her face, is that the same person? Is that not the same? Mr. Rosen had dozens of photographs to choose from. With Daniel Stark on the stand, do you remember the photograph they put on the overhead? Anybody remember that one? Lana Clarkson with her leg hiked up on a table. Alcohol all over the table, leg hiked up. At a party, obviously. They got the photographs that they want. What subliminal messaging? Come on, we've all had parties, we've all had get-togethers with friends, and someone grabs a camera and you snap a shot, and maybe you're putting the bunny ears over someone's head, or you're goofing off, or you're doing whatever. That's fine. I'm not saying there's anything wrong with the.
Wait, didn't he object to that photo? And now he's using it in his closing as a shame on them thing. Good job, AJ. That was swift. I like that.
Photograph itself. All I'm saying is take a step back and ask yourself, why did they choose that photograph? What were they thinking? Why choose the other photograph with Lana with a bright green lime in her mouth? That beautiful, sexy red dress with her her back to the camera, looking back over her shoulder. Why choose that photograph? If all you're trying to do is identify that we're talking about the same person, think about that. Is the evidence that's being presented to you trustworthy, or is there an attempt at manipulation? Little or a lot? The tequila, another peripheral issue, and this one's actually kind of funny to me because it involves you folks. The tequila, who cares about the tequila? There was a tequila bottle on Phil Spector's living room table, all right? Who cares about the tequila except for the fact that the defense made an overt suggestion, and witnesses at the House of Blues about missing bottles of tequila at the House of Blues. The suggestion was overtly Lana Clarkson stole the tequila. Now she's a thief. Well, that fell completely flat. because all the personnel at the house absolutely not. Ridiculous. We have inventory controls, and there was tequila missing, so that fell flat. That shot across the bow, if you will, about Lana Clarkson fell completely flat. Notwithstanding that, not to mention the fact that Lana Clarkson, even according to their own concessions, didn't decide to go with Phil Spector until she was in the parking lot. It was nothing. Trustworthy or manipulation? Then you folks come in. And I got to tell you, we went out to remember we went out to the jury view. You guys got to get together. Let me try that again. You guys got to get together. That makes absolutely no sense, does it? You folks got together. And talk a little bit about, and ask questions. Is there anything else you'd like to see? We got a bunch of smart lawyers up here. I think I'm probably one of them. We had the judge, and I know he's smart. He's along with us. Where are we going to look? Where it was most like to look. Foyer was obvious. Probably the first stairway landing. Not necessarily upstairs, not much of interest upstairs, really. In the bathroom, they'll probably want to glance in the bathroom and probably the living room. Maybe the front stairs. So we thought we covered all our bases. Someone among you is a friggin' genius. Someone among you got together and said, hey, I got an idea. I want to see the bar. Remember that? Somebody said, I want to see the bar. And we thought, why would anybody want to see the bar? And then I went and looked at the bar. And you folks went and looked at the bar, and lo and behold, what was sitting right behind the bar in plain view, half empty? A big, fat bottle of Jose Cuervo tequila. The defense didn't think about that, did they? When you folks went and looked at the bar. It was his tequila. It was always his tequila. Of course it was his tequila. He stocks his bar with his tequila. But they wanted to make a suggestion that Lana Clarkson is a thief who walks around hiking her foot up on a table. Trustworthy or manipulation? The defense experts actually wrote in their reports, as you heard when I cross-examined Dr. DeMaio, oh yeah, she was taking Paxil. She was depressed, because Paxil is sometimes given for depression. Yeah, absolutely. This goes in my expert opinion that she was depressed and she killed herself because she was taking Paxil. Until we learned that she actually was not prescribed for depression. Had nothing to do with depression. She had migraine headaches. Had not confirmation. Yeah, yourself. One more bit and a manipulation. The taser wire. I swear to God, if I heard one more comment about this taser wire, I thought I was going to puke. I was sitting there, and Mr. Dixon's in my seat now. I was sitting there at the table thinking, God, why, oh why, is there this suggestion about the taser wire in her feet being lifted and the taser wire being all under her feet, etc., when I'm sitting there literally looking at a photograph that shows it's not. The defense has the same photographs I have, and it literally took me, I mean, those suggestions were made over and over and over until finally I asked Mr. Dixon, come here, close this issue once and for all. Here's the photograph. Her feet weren't moved. That taser wire was wedged under the heel. Not under her foot, just wedged at the heel. You all saw the photograph, and I finally showed the photograph. Are they trying to manipulate you, or is their evidence really trustworthy? And what may rank up there with one of the most racially insensitive comments I've ever heard in a court of law. D'Souza's siesta? Pardon? In opening statement, there was a suggestion. Siesta? And there are all the words you could. We have a word for it in English. It's called a nap. What?
StreamYard, knock it off. This is a
Have all the words that can be used with regard to Adriana D'Souza was the word siesta used.
Amazing.
As it turns out, that fell flat too. He wasn't taking a nap or a siesta or anything of the kind. And by the way, he's Brazilian. He wasn't taking anything. He was awake. He had just walked around the fountain. He had just gotten back in the car. And he damn sure wasn't taking a siesta. Twisting the sleeves. This came out recently. There was a suggestion among every single one of the defense experts. Oh yeah, I'm basing my opinion, at least in part, on the fact that Lana Clarkson...
I don't know why that's true. Brazilian, they don't even speak Spanish. I don't know why that just struck me so funny. I miss that. I miss the siesta part.
Had spattered tissue on her buttons. And it started with Dr. DeMaio. And remember, it was actually kind of a good moment for me because I didn't have to say anything. I just walked up and saw Dr. DeMaio doing his hands and talking about how she killed herself. And the reason that she had to have killed herself is because she had to have fired the weapon because she had back spatter from her mouth on the buttons of her sleeve. And he didn't realize I just walked up, and one of my best cross-examination questions of the whole trial was, Dr. DeMaio, put your arm up again? Thanks, that's it. The sleeves are on the back of the buttons. I'm sorry, reverse that. The buttons are on the back of the sleeves, and everybody knows that. It's a ridiculous attempt on the defense's part. Then we get Dr. Bodden on the stand, and Dr. Bodden starts talking about this as well. I guess he didn't watch Dr. DeMaio's testimony. He didn't realize that, oh, actually, we've already closed that door. We've already put the period at the end of that sentence. The buttons are on the back of the sleeve. He probably shouldn't have gone there, but he did. Oh yeah, the buttons on the sleeve. The buttons on the sleeve, etc. Then Chris Plord stands up and shows a photograph from the defense evidence viewing, and literally, I'm not going to do it again, but I had my jacket off, and literally, they had the sleeve all twisted. I was curious. Where did that picture come from? So I start, because I have photographs from the defense, and I start looking at the pictures. The one before it was the picture that I ultimately
I need to make a shirt that says, not today, StreamYard. You know, like those shirts that say, not today, Satan. I need a shirt that says, not today, StreamYard.
picture. And they got it exactly where they wanted to, half off the mannequin, twisting the sleeves up so that they could come to court and say, oh yeah, those sleeves were facing her mouth. That is the most ridiculous thing in the world. You can put your hands up, arms up, down. There's a couple of jurors wearing jackets, men and women. You can put your hands up 15,000 times. Those buttons ain't going to face your mouth. They're just not, ever. Is the evidence they're presenting you trustworthy? Or is it an attempt at manipulation? And then we come to what I would call the whopper. I think it was Mrs. Kenny Bodden. I told you, along with her, because Mr. Cook was standing at the overhead, Elmo, thank you. And there was a photograph shown. And Mrs. Kenny Bodden stood here in front of you at this lectern, and she said, we are going to prove, ladies and gentlemen of the jury, we will prove that Lana Clarkson, DNA on the bottom of the bullet that were in that she done. It's to prove scientifically that she loaded the gun, and I almost fell out of my chair. I've been living this case for a couple years. And that's the first time I ever heard that. And I thought, my God, could I have been so daft as to have missed a report? We've given them all of our reports. They have everything that we have, folks. That's the discovery rules. And we'll talk a little bit about that a little bit later on. We have reciprocal discovery. We have to, under the quote unquote discovery rules, I have to give everything I've got. Everything. Mrs. Kinney Bodden had the exact same reports I've got. Yet she stood here. That's going to prove that Lana Clarkson loaded that weapon. And I thought, my God, if she could prove that, wow. That's a real change in the case. Unfortunately, and by the way, this is the photograph that Chris Plourde actually circled. That's where the DNA came from, according to opening statement. Unfortunately, that proved to be 100% false. The DNA and the defense had these reports. They knew this. The DNA came out of the tips, the hollow point tips that had Lana Clarkson's blood in it. You heard evidence about this, and they left this alone during the course of Dr. Lynn Harold's testimony because they knew they couldn't follow up. They couldn't prove what Linda Kinney Bodden said she was going to prove. Now, one thing you can say about the defense team, they are not underprepared. There's enough of them, and they're all real bright. So you have to ask yourself, why? Why, oh, why would Linda Kinney Bodden stand up here and tell you that Lana Clarkson can be proved to have loaded the gun? Was that just to put a thing in the back of your mind, just a twinge? Was there a hope that the prosecution would just miss that? We'd move beyond it? We'd figure out that we'd put on evidence that there was things we'd just move on? We wouldn't specify where it came from? You have to ask yourself constantly, is the evidence that they're presenting trustworthy? Is it trustworthy? Or is it an attempt at manipulation? Those are things to keep in mind as we talk about the defense in this case. And now I'm going to change gears a little bit, and we're going to talk about the way the defense really broke down. Again, they have no obligation to present evidence to you, folks, but if they choose to, you test the character and quality of that evidence. You test how much credibility, or you check how much credibility you're going to give that evidence. And their defense can be broken down into two categories. Basically, the attacks on Lana, and they attacked her over and over and over. Mr. Cutler stood up here in opening statement and said, one thing I promise you we'll never do, we'll never attack Lana Clarkson. Remember that? He said, we will never attack Lana Clarkson. And then they spent 4 months doing exactly that. Over and over and over. And the second thing is buying their science. The science, and I put that in quotation marks, the science that they attempted to sell time. The attacks on Lana Clarkson. First of all, one thing that we have to start with is there is a difference, folks. There is a huge difference, and you suicidal ideation versus the normal emotional ups and downs that any one of us has the evidence shown about Lana Clarkson. Suicidal. She had no suicidal tendencies. She had no suicidal ideation. There's nothing to suggest that she engaged in high-risk behavior. All of this disorder, and she had no suicidal attempts, no prior suicidal attempts, I should say, and never diagnosed with major depressive disorder. Now, one thing I want to make clear is Dr. DeMaio, over and over, I see one of you shaking your head. No, I will not get back into the statistics. We've beaten that down to the ground. No, we will not. However, Dr. DeMaio loved to cite statistics, and he said, well, you know, one thing that I know is depression is the leading cause of suicide. Wrong. Wrong, wrong. Being diagnosed with major depressive disorder is the leading cause of suicide. Everybody understand the difference in that? Christ, I got depressed at the end of when University of Texas football team loses, I get depressed. Luckily, it hadn't been often. I hear groans. How about this? This will bring it back home. When SC wins, I get depressed. There are the groans I was looking for. My point is, folks, I'm not trying to bring levity to a serious subject. What I'm trying to say is we all have normal ups and downs. You have a big project due at work and you don't get it in on time. Your boss chews your butt out. You get depressed. You feel like, oh crap, I let someone down. If your kids come home from school and they get crappy grades and it's the third time in a row, you get depressed. This is normal human life. We get depressed. I don't want you to be under the impression that Dr. DeMaio is saying every time someone has a down day, that's a cause of suicide. It is not. That was a blatant attempt at misleading you. Depression is not the leading cause of suicide. Being diagnosed with major depressive disorder, which is a medical condition, is a leading cause of suicide. So that wasn't work. They couldn't show suicide. They could have prior symptoms. They could show they've been diagnosed with major depressive disorder. They couldn't show any of that stuff about Lana. All they could show is that she was normal human being. So what do? They turn to Jennifer Hayes and pumpkin pie. Y'all have been waiting for me to talk about that, hadn't you? Jennifer Hayes and pumpkin pie. What did Jennifer Hayes say? Jennifer Hayes said, Lana Clarkson and me and pumpkin pie, we were each other's confidants. We were each other's go-to gals. We were inseparable. We were connected at the hip. We were the three musketeers, according to Jennifer Hayes. I loved Lana. I knew everything about Lana, and I knew the real Lana, which is real convenient, by the way. Oh, all you people, everybody else, all the evidence that says that she was a happy person, oh, that was just the game face Lana. I knew the real Lana. I got down into the dirt with her. I knew the real Lana Clarkson. Really? Did you? One of the first things you said.
Oh, for crying out loud.
I think she wished she could have taken it back. She said, one of the first things you said on cross-examination, actually it was direct examination. I think it was a faux pas. I think she wished she could have taken it back. She said, I'm Pie's memory. I, Jennifer Hayes, am Pie's memory. Pie has such a poor memory. Pumpkin Pie can't remember her name if I don't give it to her. She has such a poor memory that I'm actually her memory. What else do we know? We know that Tawny Tindall, but amazingly, there's no recording of that interview. And she interviewed her with another person. She interviewed Jennifer Hayes right alongside another person. Who could that person be? The three of them sat and chatted together, and what do you think they did? Do you think Pumpkin Pie might have helped Jennifer Hayes a little bit get her story straight? We're going to get to Pumpkin Pie in a second, and her motivations in this trial in just a second. But do you think that their testimony sounded just alike enough that it's suggestive that they might have gotten their story straight? One thing's for sure, you will never know. You'll never know. Because Tawny Tindall and the defense made sure that those conversations will never. So you'll never know. You have to ask, testified. Was it hers? Was it Pumpkin Pie's? Roger Rosen even talked to Jennifer Hayes at one point. That wasn't recorded either. Whose testimony were you really listening to? And then we find out that Jennifer Hayes is about the cottage. This is the inseparable, the person that is closer to her than anybody else. They trade confidences and intimacies. They talk constantly. They know each other's good moods, bad moods. I know the good moods, bad moods, and I, Jennifer Hayes, know the real Lana Clarkson. Really, how long has she lived?
Okay, guys, I'm turning the camera off. I'm sorry.
Guess she didn't get that one straight during her conversation with Pumpkin Pie. Lana Clarkson lived in the cottage for about 2 years, a little over 2 years. Jennifer Hayes doesn't even know where Lana Clarkson lived. I'm not saying they didn't know each other. You have to question whether or not they knew each other in the way that Jennifer Hayes said they knew each other. Keep in mind, you got no corroboration about their relationship except one person. Pumpkin Pie. Interestingly enough, you'll have available to you, and I don't suggest you do this, it takes a long time. Actually, I suggest you do it. What the heck? You got nothing but time anyway, right? We presented you with phone records, cell phone records from Lana Clarkson, cell phone records from Jennifer Hayes. Not one phone call in the last 3 months of Lana Clarkson's life. Not one call received, not one call made. Well, you know what? We're a male society. They don't talk on the phone. They get together all the time, intimacies, email. You know what a preliminary for? Oops. One email in evidence that you have between Lana Clarkson and Jennifer Hayes. Whose testimony were you really listening to? Hers or Pumpkin Pie's? And Pumpkin Pie, who without question has chased the limelight from the day Lana Clarkson died.
Yeah. Court TV's being extra today, too.
Having her own memorial at some club that she was promoting. She was so devastated on Monday. She got up on Tuesday and promoted another club. Oh, I had to be dragged out of bed, and I was dragged out of the grocery store, and I collapsed, et cetera, et cetera. Oh, please. She was promoting a club the next day. I'm not saying that she wasn't hurt by Lana's death. I'm not being insensitive to her hurt. I'm saying, can you really believe this sob story that Pumpkin Pie was trying to sell you? Let's think about this. You have to test the character and quality of her testimony on this witness stand. Because, folks, the reality is, if it didn't come through that microphone, or it's not presented to you physically, it ain't an evidence. All right, what comes through that microphone is evidence. So you can test how Pumpkin Pie acted and reacted. You can test the character and quality of her testimony just by how she acted on the stand. How was she dressed? Did she come dressed appropriately? Or did she look like she was looking for attention? Everybody thought about that. Of course, the defense got her cleaned up the next time she was called to the stand. Or somebody got her cleaned up the next time she was called to the stand. Did she really look like someone who had just lost her best friend and is in the trial of her best?
He even used the picture from the day she came showing her boobs. Oh, no, he didn't. Oh, my God.
Friend's death as she tries to give over the truth about her friend? Or did she look like she was trying to draw attention to herself, just with her appearance, before she even started talking? I don't think I'm putting too fine a point on it when I say, in determining whether or not she seeks attention for herself. Is she the type? Is she an attention seeker? She named herself Pumpkin Pie. I mean, it's not like she went home to her mom and said, you know what, I don't like Irene and I don't like Elizabeth and Laughlin. It's not
ever
really working for me, so I'm going to change to Susie or Joanne or Michelle. No, she said, you know what? I think I'm going to change my name to a Thanksgiving Day dessert. Pumpkin Pie. Someone who's, and look, she can change about that. I'm saying is, you have to ask yourself, this part and parcel of her attempt to draw attention to herself. That's what she craves. The attention to herself. She used Lana Clarkson to tall, gorgeous, blonde. And she meant to draw attention to herself. When we approach sidebar, again, you test the character and quality of everybody's testimony and you watch their demeanor. That's why they testify live in front of you. So you can watch their demeanor. What was Pumpkin Pie doing? We approached sidebar at one point, and Judge Fiddler and Mr. Rose. Pumpkin Pie has brought friends, a little entourage, who was sitting in the back of the court.
Oh, come on. I gotta hear this. I need to know.
Pumpkin Pie doing? We approached sidebar at one point, and Judge Fiddler and Mr. Rosen and myself has brought friends, a little entourage, who was sitting in the back of the court.
Dang it.
Didn't come out on direct examination, but on cross-examination, she admitted, oh yeah, there's something going on, there's a treatment there, and blah, blah, blah. Well, who would buy a book about Pumpkin Pie? I mean, really, if it wasn't for this case, who would buy a book about Pumpkin Pie? Is that something that you think, and you're smart folks,
Gosh darn it.
the publishers would try to publish a book about a LA club promoter that does clubs here and there in LA? I don't know. Maybe it'd be a #1 bestseller. I don't know. I don't think so. However, you change that a little bit, you tweak that a little bit, and all of a sudden Pumpkin Pie becomes the star witness for the defense in the Phil Spector murder trial. Maybe that might sell a book or two. Chasing that pie. And then talk some what's going on, and literally Jennifer Hayes had been given information by Pumpkin Pie. Say this, don't say this, say that. Which, none of which, by the way, is borne out by the evidence. No phone calls, no emails. She was asked a question she probably wasn't expecting. How long has Lana lived in the cottage? Oh, the whole time I've known her, 8 years, 9 years. You know, hoping for the best. Oops. Here. When Pumpkin Pie was brought back to the stand, she said, oh yeah, and by the way, just in case you were wondering, by the way, Lana always has her purse on her shoulder. Why did that come up? Why would that come up? Because the defense knows good and well that one thing they can't get by, one thing they can't get over, one thing that will never, ever make any sense is that Lana Clarkson killed herself while she had her purse on her shoulder. Is having her purse on her shoulder more consistent with committing suicide, or is it more consistent with saying, hell, I'm ready to leave, I'm ready to go home? They can't get past that. They cannot ever get past that because it makes no sense, and they know it. So what do? Here's the Hail Mary. commercials, Mikey? Give it to Pumpkin Pie. She'll say anything. Remember Mikey, he'll eat anything? You know what? We're screwed on this purse issue. We can't get by that. The purse is the purse is the purse. It's on her shoulder. How do we explain that? Oh, well, I got an idea. Just give it to Pie. She'll say anything. Have her testify that Lana constantly had her purse on her shoulder. Every single time she saw her purse was on her shoulder. So Pumpkin Pie says, tell the truth, the whole truth, nothing but the truth. Lana always had her purse on her. Get out of here. Really?
Dang it. Stop, Court TV. What is your problem? Oh, stop it. Really? This was so good. What are you doing? Ugh. Court, I hate this website. Why are you buffering so bad?
Well, I got an idea.
Seriously?
Just give it to Pie. She'll say. Yeah? Just give it to Pie.
My stripper name is Serendipity. That's a line from Warehouse 13. You guys remember that show? I love that show. I didn't know what that word meant. One of the characters, Claudia, she said, my stripper name is Serendipity. I had to look the word up. I didn't know what it meant. Hey, Nancy. There's an episode of Supernatural where there there's a siren. You know, siren like the old mythic sirens that sailors would crash their ships because they heard the siren call and it would um lure them to the rocks to crash their ships. Well, in Supernatural there was a modern day siren, and he would shape shift into strippers and lure men into killing for it ended up being a guy, not a female, it was a male. um Nancy. And when he would shapeshift into these strippers to lure men to kill, all of his stripper names were Disney princesses. It was Aurora and Jasmine and Ariel. Well, now I can't get the camera to turn off. StreamYard. Oh, and now I can't get it to share. It's frozen. Unfreeze. See, now I need to be Elsa so I can unfreeze StreamYard. Come on. Oh, there we go. Oh, wait. No, I'm already. Oh. Wait. Oh, what did I do? There it goes. I think. Come on. Yay. Now, behave.
Did you? Not one photograph has her with a purse in it. Not one photograph has Lana with her purse in it. One person in this trial who admitted lying. An admitted liar, and that's Pumpkin Pie. She said, yep, I lied. He's got an excuse for it now. Well, yeah, I lied to Detective Tomlin. I didn't tell him the whole truth. Well, let's see about that. Her first statement to Detective Tomlin, as you recall, was Lana was not suicidal. Lana was never depressed. The only time she was depressed, Lana Clarkson, was when she actually broke her wrists aimlessly, because that's how Lana fell. She slipped on a rug and braced herself and snapped her wrists. 21 fractures, 3 surgeries, pins, halos, literally pins drilled into her skin, through her skin, into her bone. Was she depressed then? According to Pumpkin Pie, yeah, she was a little depressed then. Well, my God, who wouldn't be? Who among us wouldn't be? You're not going to get up and click your heels and sing a happy tune the next day after you have several fractures with your wrist. Of course she was a little depressed. Detective, was she depressed on February 3rd? Is she depressed now? And remember, this statement came just hours after Lana was shot to death.
Coke? Or what? But you don't get fractures from falling. Spiral fractures are a twist. So I don't know if Coke, that, because
No, she's not depressed. She's definitely not suicidal. Then Pumpkin Pie, chasing that limelight, decides she wants to talk to Star Magazine. She had a pathetic excuse about what happened, but basically it went like this. The family decided they were going to have some dignity about this case. They had suffered enough. They had suffered the loss of their daughter, their sister. They had suffered enough. This case was not going to be tried in the press. So they gave basically standing orders. Nobody close to us will talk to the press. Pumpkin Pie, to hell with it. I'll talk to the press if I decide to. So at one of her clubs, this Star Magazine reporter shows up, and they have a conversation. And remember what Pumpkin Pie's testimony was when she started on direct examination, under direct examination by Mr. Rosen. The direct examination went something like this. Lana Clarkson was my best friend in the world. She was my whole world. She was my sister, my inseparable sister. She was my best friend. We talked 3 to 4 times a day. I knew her better than anybody. Star Magazine article comes out. An anonymous person who claims to be Lana Clarkson's best friend, her best friend in the world, someone she cares about, someone she shares confidences with, someone she talks to 3 to 4 times a day. Pumpkin Pie on the witness stand? That's not me. I don't know who that is. That's not me. Right. So Star Magazine comes out, and rightfully so, the family says, you know know what? You have broken the cardinal rule. We decided we are suffering, we're mourning, we have suffered the loss of our loved one, and you're out self-promoting at Star Magazine. You're done. You're exiled. It wasn't that formal. I'm putting more formal words on it. Basically, they said with dignity, you know what? We're not going to talk to you anymore. We're not going to give you information. You're not going to be sort of in the inner circle. And that drove Pumpkin Pie nuts, because where does she want to be above all other places? In the spotlight, in the inner circle. So she wasn't getting information. Then she picks up Vanity Fair. Picks up that article in Vanity Fair. Begins to flip through the article. And lo and behold, the Kessel brothers' name is mentioned in the article. And she thinks, wait a minute. You know, I promote at all these clubs all over LA, and Backstage Cafe. They, or one or both of them, are interesting. That could be interesting. I'm not in the inner circle with the family. Is there someplace else that I could bring attention to myself? Spector, not just acquaintances, not compile what she read and what she conceived, is that the Kessel brothers were the sidemen of Philip Spector, like sons to him. Wow, what a connection. And that's the guy that killed Lana. The next thing you know, the next time she talks to the authorities, her stories flipped 180 degrees. 180 degrees. Now, all of a sudden, now Lana Clarkson's suicidal. She's depressed. She wanted to kill herself. Kessel's backstage. And as of today, she's no longer promoting at Level 1 and Barfly and China Bistro. She's promoting at one place. She gets all of her finances from one place. 100% financial support from one place. Where is it? Where is it? Backstage Cafe. Coincidence?
Before you switch subjects, there's a couple matters we need to do, and I want to leave enough time. So, ladies and gentlemen, keep in mind the admonition will resume at 1:30 this afternoon. Council will remain, the audience will remain quiet until I have disposed of the issues I have to raise. Thank you. You may take your recess. Thank you. All right, the jurors and alternates left. Mr. Rosen, you indicated you wanted to raise certain objections.
Yes, we did. One thing that I thought, I spoke with Mr. Dixon about this, clips which will be shown and have been shown by the prosecutors as well as the fact that will be shown need to be preserved for the record. So Mr. Dixon suggested that they will. And we do have a number of issues, and I think Mr. Reardon wanted to start off with them. If that's okay.
Okay.
Your Honor, we have an application for a mistrial. The state has just engaged in the form of improper argument that it asked for assurances that we would not engage in last week. That is to say this. Both sides in this case came to the court and said, not as a matter of tactics, but as a matter of law, there is insufficient evidence to support anything other than a second-degree murder conviction or an acquittal. Prosecution's theory is the defendant put a pistol in the fire evidence on which she defined accident. In fact, the court admitted uncharged defense evidence because there was evidence to support the defendant did a lack of evidence to him or an effort that his mental state was befuddled, and he could not have consciously disregarded the danger to life that that act obviously would present. And therefore, the court said, I agree, no involuntary instruction in this case. Mr. Jackson then said, Your Honor, here's what I fear. I fear that now that they've got Terry out of the case, it up and somehow suggest that this was an accident, there wasn't conscious disregard, he was intoxicated and so forth, and we'll be in a position where we don't get our lesser, and they're arguing for a lesser, and the jury has to acquit because it's not second-degree murder. They've argued that it's an involuntary. And the court said that would be wholly improper, and I would sustain an objection. Here's the flip side thing. Okay, we only have a second, okay? The jury hears about conscious disregard. All this, and the prosecution starts with the voluntary theory. It says, oh, if you point a gun at somebody and there's an earthquake and it goes off, that's second-degree murder. If you point a gun at somebody and you're intoxicated and there's an accident, that's second-degree murder. That is hogwash. Everyone knows, state, anyone would know, any criminal lawyer would know, that in such circumstances such as that, a jury could A, find an accident, there was an earthquake and acquit entirely, or B, would find that while the dangerous act on the part because they were given, a jury would realize we're in the jury room, someone says that's involved. The jury doesn't know that because the prosecution has opposed the involuntary instruction on the grounds that it's improper on these facts, and then describes an involuntary to the jury and says it's as a matter of law. As a matter of law, if you point, and I quote the argument, if you point a gun at somebody and it goes off for any reason, that is nonsense in the second degree. That is utter nonsense.
I disagree. I think if you point a loaded gun at someone, oh, Jelly Bean, thank you so much. Thank you, sweetie. I disagree. I think that if you point a loaded gun at someone, even if there's an earthquake, even if there's something beyond your control, that it's still your fault. You shouldn't be pointing a loaded gun at anyone, ever, unless you intend to shoot them. It doesn't matter. Like, if you're just showing someone your gun, it shouldn't be loaded. So I think I disagree with his argument 100%. Who are you trying to get, Jill? Congratulations, Donald, Nan, Lori, Marty, and Martha D. You all have been gifted memberships by Jelly Bean.
So the only remedy the court has is either to mistry the case, or it's going to have to do this. It's now going to have to educate the jury on what an involuntary is and say, if, as the prosecution says, Mr. Jackson said, you're back in the room back there, and number 12 says second-degree murder. You're going to have to educate them on what involuntary manslaughter is and say, give the classic instructions, if you find a reasonable doubt that this is involuntary as opposed to second, then you must acquit, or you have to reverse your decision not to give lessers, because they have just, this jury has to know that Mr. Jackson's argument that any pointing of a gun which results in a death is second-degree murder is under California law clearly incorrect. And in that situation, they would have to decide the existence of thought as opposed to reckless and involuntary. We ask for mistrial, or we ask for the court to instruct on the nature of involuntary, or the court can simply instruct the jury that they need to entirely disregard Mr. Jackson's argument that a killing by accident or by any constitute under California law a second-degree murder as a matter of law. That's the first application.
All that you want to raise.
Early in the argument, Mr. Jackson made what may have been a very effective argument, saying, you are at the scene of the crime. You stand next to Lana Clarkson. What do you whisper in her ear based on what you have learned in this trial? Your Honor, under People versus Stansberry and People versus Fields, I can give the court the citations, both California Supreme Court citations. We have settled, and I quote, we have settled that an appeal to the jury to view the crime through the eyes of the victim is misconduct at the guilt phase of a trial. An appeal for sympathy for the victim is out of place during an objective determination of the facts. Fields says it can lead the jury to depart from their duty to view the evidence objectively and view the case through the eyes of the victim. Essentially, what the prosecutor has done is ask the jury to counsel the victim about what she should do in the situation. It's clear that depart from their role. Evidence, a portion of the argument that it essentially be stricken as inappropriate. That's number two. Number three. At one point, Mr. Jackson argued distrusted and quote the testimony of a defense witness. You have
Wow, thank you, Judy, so much. StreamYard is not showing me comments. Trying to figure out what's going on.
Obligation to consider whether his or her testimony is still credible in other respects. There is no principle of law that you have a legal obligation to ignore testimony to which you distrust. The fourth point would be repeatedly Mr. Jackson used the term I, such as I was aghast. Describes a meeting with Mr. Dixon, where I asked Mr. Dixon this up. I was photographed, went to the bottle of tequila, and another said, I almost fell out of my chair. At another point, he said he came up to the podium and he saw the pumpkin pie, looking at friends, waving to friends. In each of these instances, for the prosecutor ever to bring to the jury's attention his mental reactions or particularly his observations. I mean, he's certainly entitled to ask the jury to recall whether they saw something in the courtroom involving pumpkin pie, but it's clearly inappropriate for him to inform them of what his observations were, either during the jury view or in the courtroom, or his emotional reactions. A separate point is that Mr. Jackson is entitled to argue that pumpkin pie, and then said another. He's entitled to argue that she testified to some effect, but other evidence contradicts it. It's gross misconduct to say what happened in this case was that the defense lawyers realized that they had a particular problem and they would instruct pumpkin pie to testify in a particular way. It's an attribution of misconduct which is unfounded. It's false. Mr. Jackson doesn't know that. He is using the respect that a prosecutor has to inform the jury of something that they couldn't possibly know and that there's no evidence of. And so attributing an intent to have a witness testify falsely to the defense counsel is misconduct. We'd ask for an admonition on that score, Your Honor. If I can have just 1 second. I'll defer to Mr.
Thank you, Your Honor. Mr. Reardon, the major points, but there are a few others. I would like to just footnote the one point that he made. I think it was point number 1 or number 2, where he was talking about in Mr. Jackson's opening remarks when he suggested to the jury, come out to the parking lot with me now. Come out and see what's going on. And if you could whisper one thing to Lana Clarkson and very dramatically say, what would it be? Don't go. What he's really done there, and I embrace Mr. Reardon's comments, is he's asked them to serve as advocates, but he's done it in a very clever way. He's once removed it. He hasn't asked them to be Lana Clarkson. He's asked them to be the advisors to Lana Clarkson, and that's not a juror's obligation. The juror's obligation is to serve as the judges of the facts. That's their sole obligation, and apply the law, not to serve as advocates. So I footnote Mr. Reardon's comment in that. Secondly, following comments, he said, you throw enough money at a problem and you solve the problem. And that's what Phil Spector does. And he folded that into a couple of other comments, stating that we're here to seek the truth. Was the defense evidence trustworthy? And then multiple times stated, are they trying to manipulate you? These are personal attacks on the defense team itself. I think there's by way of innuendo, certainly is out there, that Mr. Spector hired a bunch of lawyers here because he had the money and the ability to do that. There's no place for that in this case. Everybody stands before the bar equally, and all lawyers are to be judged equally. By comments that Mr. Reardon made, and I want to add one other, where he indicated, that is, Mr. Jackson, I've been living this case for 2 years, and did I miss something? A prosecutor, and I was a prosecutor in this very building for 6 years. And one of the first things you learn is you are not allowed, even a zillion years ago when I was a prosecutor, to make comments that express your personal beliefs as a prosecutor to that jury. And when you start embracing the pronoun I, that's exactly what you're doing. And here, and I think those are points that also needed to be made, that they support what Mr. Reardon said. Thank you.
Very good. With regard to the first point about the second-degree murder argument, it's a perfectly appropriate argument. Like you point a firearm, stick it in someone's face, it ends up in her mouth, and you're doing it in a threatening manner, and the gun goes, that's implied violence. I don't have an intent to kill. I don't have to prove it. Reason, and that is, in fact, for any reason, second degree murder. So I don't know where Mr. Reardon is coming from when he says, now we're saying, when the court said last week, folks, the crime here, if the gun was in Mr. Spector's hands, the crime is second degree murder. I mean, that came out of the court's mouth when we were discussing the appropriate instructions and subordinate instructions, or lesser included. Everybody agrees, as did Mr. Reardon. If the Mr. Spector getting off. With regard to putting someone in the eyes of the victim under Stanfield and Stansberry and I didn't ask the jury to put themselves in the eyes of the victim. I asked them to put in a position where they could watch the conduct of Philip Spector. They could watch the conduct in their mind mentally. This acts. There's nothing inappropriate about it. With regard to distrusting witnesses, I have, as a matter of fact, one of the next slides, I actually quote the language. Not trying to play fast and loose with the language of Calgic with regard to, Calcrim, with regard to the juror's obligation or no obligation to distrust anything the witness said. The Calcrim is very clear. If you distrust something that they said, the witnesses said, you can ignore or you can distrust everything that came out of his mouth. whether or not Pumpkin Pie was instructed or Jennifer Hayes was instructed, I constantly said, if in fact you find that their testimony was a little too close to one another, and you can what she told, what Hayes told what to say. They could conversations with Tawny Tindall, they could draw that into conversations with the defense, they could draw that into conversations with each other. There's nothing inappropriate about the defense. And that is a perfectly reasonable argument with regard to this case. There has been an extraordinary amount of money that Mr. Spector has spent on these defense experts, and that I intend to exploit. I have never said that Mr. Rosen is wrong or there's a personal attack against Mr. Brunon or Mr. Plord because Mr. Spector hired them or spent money on them. If they spent money on them or not, this may be pro bono for everybody. Who knows? That's not in evidence, and I haven't talked about that. What I'm saying is, and what I said was, you hire enough lawyers who hire enough experts and pay them and what you have to question the character and quality of the defense presentation. Defense evidence is a phrase that I conceived of within prepared, because I know I can't say, and I wouldn't suggest that Mr. Rosen is doing anything untoward. I'm saying this presentation of the evidence must be viewed for its character and its quality. I don't believe that that any of my arguments have offended the law in any way.
Okay. I'm going to try to take him in order. To the second-degree murder, somehow they're putting in a different theory or they're misstating the law. And, you could, under Mr. Jackson's theory, charges, if you put a gun, and I'm just using this as a, illustrative point. If you put a gun in somebody's mouth and you trip or you suddenly fall down, too bad for you. Yes, it's an accident. You didn't mean for it to happen. It's the...
Agree with you, and perhaps we can focus this in. Mr. Jackson, in his argument, just did something that he never argued to the jury. He never said to the jury, if you put a gun in somebody's mouth and it goes off for any reason, that's second-degree murder. His words were, if you point a firearm at a human being, second-degree murder, no matter how it gets hooked up. We could probably solve this by the pinpoint instruction. And the jury, the theory is that the act dangerous to human life was placing a gun in Miss Clarkson's mouth, and if they don't find that occurred, then we're on the same page. But the argument that he made by never mentioning that placing a gun in her mouth implied to the jury that they could find that he was waving a gun around or standing across, and the gun, if for any reason, would be second-degree murder, which is wrong as a matter of law. So as long as it is clear that the argument to the state had nothing to offer any, we could find that he just brandished it. If it goes off for any reason, he uses the word earthquake. That if it goes off because of an earthquake, even if he's standing away from her, second-degree murder, it's incorrect. So I think what we're going to need is an instruction that says that the act which they have to decide is the placing it in her mouth.
But there's more than that, and the problem with your pinpoint your pinpoint is not the law. Now, I'm not going to sit here everyone. If I indicated to you at the beginning, if you want to submit a revised instruction, I'll take a look at it, and if I think it properly states the law, that's wonderful. I'll also point out to you that the jury was admonished at the beginning of the argument that what attorney said didn't control. It's the instructions that I give them that controls, so the bottom line is they'll have that. So that, I think, properly replies to the first argument. The motion for mistrial is denied. The number two, I don't believe the, what would you whisper in your ear is putting it in the eyes of the victim. I disagree that falls under the you have something specific you want to point out to me where similar language you cannot use, of course, I will change my opinion. I don't think it's a violation. The third point that was raised, let's see.
If you discuss the witness in one part, you can discuss.
Right, thank you. And my note is you need to clean that up. If you're going to do so in your argument, that's fine. Otherwise, I will do a curative admonition because I don't think that's the appropriate. If you clean it up, that's fine. And you may, you should point out that you may have misstated the law because otherwise I'll take care of it. But sure. Couple problems with 2000 by the question of throwing money at a problem that's entertained because of the two things and saying I've lived with the case for 2 years, that's not inappropriate, and there's no problem with that. There are two things that I did find some problems with. I do believe that in talking about the witnesses, you seem to indicate that defense counsel was giving them a story, and that's disparaging counsel. There's no evidence of that. And say a mistake, or if you think I was saying it, I'll take care of it. It's your choice, one of the. And there is a problem we do have, and this is the observation quote of the tequila bottle and of pumpkin pie waving. I'm not saying they weren't there. I know I never saw either one. I was in the bar. I didn't see a bottle of tequila. I don't know if the jurors saw the bottle of tequila. You may have seen it, but that's not an evidence. Pumpkin pie waving, she may have waved. I didn't see it. So that's the problem. The defendant's present with his counsel, the district attorneys are present, and the jurors and the alternates are not present. Just to basically address the issue that was raised about whether any possible thing that caused the weapon to destroy a basis for second-degree murder. The answer is in the abstract, no, that is not a correct statement of the law. Under the facts of this case, however, it's sort of yes, because the facts that might make it non-existent are not. It's a question of proximate cause, and it depends whether the act that would cause the gun to discharge in this case was an act the cause was foreseeable by the defendant, and I'm citing language from a case, and I'll give you the case in a second, or if not foreseeable, whether it caused injury of a type which was foreseeable. If either of these questions is answered in the affirmative, then the defendant is not relieved from liability. If, however, it is determined that the intervening cause was not foreseeable and that the results which caused it were not foreseeable, then the intervening cause could become a supervening cause and the defendant is relieved from liability. Well, we don't have that, but that is the general language. So your language was too broad, but it really doesn't change the facts of the case. You might want to address that, and we'll go from there. Okay, we'll see if we need an instruction on it at some later time.
You were going to give us a cite on that?
Oh, I'm sorry. It's a Court of Appeal case that cites a ton of cases, and it's this is actually People versus Brady.
I'm sorry, Brady or Brady?
Brady, B-R-A-D-Y, 129 Calap 4th, 1314. Mr. Reardon.
Your Honor, we have submitted a supplemental pinpoint instruction. I don't think the court wants to address it now. We could do it at the close of the session. Which attempts to address the exchange between counsel just before the lunch break.
All right, I'll take a look at it. Thank you. Let's bring in the jury.
Okay. We are halfway through prosecution closing arguments, and that maple glazed bacon donut sounds amazing. I might have to get my donut recipe book out and bake some donuts. I have a baked cake donut recipe book, and I've only done, which ones have I done? I don't even remember. It's been so long since I've made them. Actually, I'll be better off making protein waffles, which is probably what I'll do. So I can catch it when it crashes. Okay, so now, I didn't set up a portal. You guys are gonna have to find it on your own. But now we're gonna go to Wackadoodle trial. Red velvet. There's a recipe for red velvet in the book. I prefer the other kind of donuts to the cake, but I like cake too. I just prefer the other kind. But I guess you can't bake the other kind. They have to be fried. So these are all cake donuts in my recipe book because you can bake them. And I bought the baking donut. It's like a brownie pan, only it's donuts. And you can make bagels in it too. I've done the Weight Watchers has a recipe where you use Greek yogurt. What's the other ingredient? It's 2 ingredients. It's Greek yogurt and something else. Flour, maybe? I don't remember. It's just 2 ingredients. And you make bagels. I made bagels in the donut pan and baked them. They were so good. I've never heard of duck donuts. And we do not have Tim Hortons in Florida. I want to go to Tim Hortons so bad. And I've never heard of duck donuts. I bet Disney has some somewhere because Disney has everything. I want to try poutine so bad, and Disney Springs has poutine. But there's for the Mickey Halloween party, they have bootine, and it's got crawfish in it, sausage, gravy over waffle fries and cheese curds. And I I sent like a little clip of a video to Robbie Dobby, and I said, "Is this poutine?" I know they gave it like a cutesy party name. It's bootine for the Halloween party, but is this poutine? And she she texted me back and she goes, "Steve said, what the heck is that?" I said, "Okay, good to know." She said, "Classic poutine is French fries and cheese curds with beef gravy over it." And um when I was a kid, mom would make us French fries with beef gravy over it, and we would eat it like that. And I've not done that since I was a kid. So basically, I ate poutine without the cheese curds when I was a kid, and I'm dying to eat real poutine. But I'm not crazy about crawfish. I'm not crazy about sausage. So I think I'm gonna skip that when we go to the party. But they have real poutine, supposedly real poutine, at Disney Springs. So I'm gonna have to go to Disney Springs and get me some. But yeah, Tim Hortons, we don't have Tim Hortons. They're like Canada. I guess, do they have them in Ohio, Judy? But yeah, I watched one of my Disney vloggers. They went on a Alaskan cruise, Disney cruise, so they had to go to Canada to get on the cruise ship, and they were so excited to go to Tim Hortons, and then they were like, "Oh, it's just a coffee and donut place." And I was like, "I thought it was this amazing place," and they were like, "Oh, it's just a coffee shop." It's like, okay. But yeah, I would love to go to Tim Hortons because I've heard so many amazing things about it. Okay, guys, so I will see you at Georgia v. Nicholas Casotis, and I'm sorry I didn't do a portal. So, but you guys know where to find me. So I will see you over there in a few minutes. Bye.